it will be appointed. The timeline within which the recommendations of the selection committee will be processed, and then 3, the members of the search committee and the list of the candidates who have applied. These details be notified in terms of the directions issued by the court in the Anjali Bharadwaj case. They have still not done so. 10 months from your lordship's direction, they have still not done so. Then further, the affidavit should specify that candidates who did not apply in response to the advertisement shall not be offered appointments. And their affidavit says that no, we will offer appointments to those who did not apply also, in defiance of your lordship's order. And my lord, we are now 10 months from your lordship's last order. At least 6 orders have been passed by this court, one after another, saying that you appoint. And today the situation is, my lord, that even that one CIC has retired. There are only 2 ICs working out of the 11 total. And they are there, and the pendency is just skyrocketing. The whole the Right to Information Act is being destroyed by not appointing information commissioners. Their affidavit says, no, we will appoint even those who have not applied.
Yes.
No, where is the affidavit after this order?
Yes. See the affidavit, my lord, 30th January affidavit.
Where is that affidavit?
Affidavit of 30th January of Union of India. Just give a copy. Do you have a copy? Achha. 30th January affidavit of Union of India. They are searching. I can read in the meantime, Lord. Let me just read out what they are saying. They are saying it is further submitted that the role of the search committee is to supplement the recruitment efforts made through the advertisements and to assist the committee under Section 12 of the RTI Act in selection of suitable candidates in terms of eminence specified. It is up to the search committee to devise its own modalities for shortlisting the candidates within or out of the applications received in response to the open advertisement.
So, Bhushan, that may be, you see, let us not doubt everything. Sometimes what happens, there may be a person of very eminence.
Yes.
He may not apply.
Yes.
Because he does not want to be, subject
That's why, my lord, this court had said, and that's why your lordship's last order reiterated that. Your lordship's last order said that you must file an affidavit and state that persons who do not apply will not be appointed. Why? Was this order necessary? This order was necessary, my lord, because earlier what they had done was they ignored the applications and they skyrocketed, airdropped one gentleman who had no experience whatsoever in RTI, etc. He was supposed to be some journalist who was singing praises of the government, etc. And that journalist, without having any qualifications, etc., was airdropped. The whole object of this original order was
that sometimes, you see, personal opinion, subjectivity, that may sometimes create problem. Let us take an example of,
yes,
and that's a problem which probably not only the Supreme Court, even the High Courts are facing.
Yes.
There are lawyers who say, we have not submitted my application for being designated as senior. So what do we do? In the rules earlier also, and now probably the Supreme Court on judicial side has explained that let there be a power of designating suo motu.
Actually, my lord, that may have been all right in some cases, but here what was happening was...
No, this is what we are saying, that in some cases, and let me give you the example, at least which we did. If somebody might be knowing, Mr. Anupam Gupta in Punjab and High Court, he never applied. then in the full court, I fought tooth and nail that this power of suo motu should be exercised in some good cases, in reasonable cases. One of the justice, former judge now, Justice Randhawa, supported like anything. We both of us then ultimately persuaded the entire house, agreed that we should exercise suo motu power. We did it. I don't know what is wrong, but it is not that he does not have critics. There are people who will criticize him also because nobody is spared in the system.
So, my lord, then in that case, what they need to do, because your lordship's order said that put out all the names of all the people who have applied, put out the shortlisting criteria, and also state that people who have not applied will not be appointed. Now, if your lordship feels that that part of the order needs to be relaxed, which means that even people who have not applied may also be appointed, at least their name should be put out. How can they go ahead and just appoint somebody out of the blue and nobody in the public? This is, my lord, appointment as information commissioners under the RTI Act. RTI Act is all about transparency. Now, no transparency about the person who is going to be appointed. Nobody comes to know. People who have no qualification, just a journalist who's singing praise.
Let him make all these arguments. When somebody is appointed, he can point out about somebody, not before somebody is appointed. Now we are in the process of appointment. Search committee comprises of several persons we have pointed out along with the affidavit at page number 5. That's comprised of chief cabinet secretary, and 3 department secretaries, 1 eminent person. There is a composition of search committee, 5 members. They will make a search, then they will recommend it to the selection committee. Selection committee comprises of Honorable Prime Minister, Leader of the Opposition, and 1 more nominee of the government. So 3 members, we have to trust them. And finally, they have to make the selection. Yes, now the search committee has made the recommendation, has completed its process. It has gone to the selection committee. The selection committee will be able to complete the entire process within maximum 2 to 3 weeks. The entire selection process will be over. And then, one second, sir. Then in respect of in respect of any particular candidate, any eligibility issue or anything which is not in conformity with the act, that is a later issue which will have to be this one examined. Now he is saying that somebody will be appointed from air, he can't drop something before the court and make this argument to the gallery. So let us wait, let the appointment be completed.
We have been waiting for the last 5 years. 5 years, my lord, your lordship has been making the same orders.
You are right. There is a long delay, but now that a matter of 2-3 weeks.
But 2-3 weeks every time they said, last time in January they said, it will be done in the next few days or few weeks.
I am making this statement.
What will do it? What we are proposing now, the reason is the matter also unfortunately not listed.
But why should this not be in the public domain? Who are the people who are being considered? Your lordship ordered that. Who are the people who are being considered? So that, Lord, aren't we as citizens entitled to know who are being considered for our right, for the Right to Information Act?
Those who are under consideration, Mr. Bhushan, they don't know about their grandfather and great grandfather, but people will make them alive. So let us.
That's not the issue, my lord. The point is there was a good reason. There was a good reason why this court, after a very exhaustive hearing, gave those directions. Shortlisting search committee should be put out. Shortlisting criteria should be put out. Names of the applicants should be put out.
Let us do one thing.
How can
we will keep all these issues alive.
Yes.
We are not that these can be ignored. Each aspect will have to be examined.
Yes.
So let us see that how it is done in 2 weeks or 3 weeks time, and we.
But at least, Lord, why should they not first put out the names of the people who are being considered, including suppose they are considering somebody who has not applied? Why should his name not be in the public domain?
These people are ready with the anonymous complaints. They will target them. They will file the complaints. They will tarnish their image, and ultimately entire process will be derailed. So, whatever the argument, let them argue after the appointment is done. So, not at this stage.
Let the person be murdered, and thereafter you can.
No, you will plot every murder.
This is the kind of argument. Let the appointment be done, and thereafter you can raise this issue.
Appointment can't be the fait accompli because ultimately matter is sub judice before us. We can definitely take a call.
But, my lord, if these things become fait accompli, I am saying, Lord, what is the objection? Suppose they are saying that, all right, we want to consider somebody who has not even applied. But let that name be put out in the public domain. Your lordship had said all those who have applied be put out in the public domain.
Public domain name in any case will come in public domain.
No, your lordship said that before the appointment, very clear. Even earlier, my lord, the court's order says very clearly that before the appointment, it has to be put out in the public domain.
We don't think that in order of 7 January we said.
Yes, yes. See the 7 January order. See the order of 7 January, if your lordship sees. The members of the search committee and the list of candidates who have applied, these details been notified in terms of the directions of this court issued in the Anjali Bharadwaj case. And this court had said that you have to notify it prior to the appointment. This is the whole object of this order. And neither the members of the search committee, nor the members of the search committee is in public domain. The shortlisting criteria has not been provided. The names of the applicants have not been provided. Shortlisted candidates have not been provided. Nothing has been provided, and they want to appoint somebody who has not even applied.
No, we don't know whether they will appoint somebody.
No, they have said so. They have said so in their
They
affidavit.
are only referring to the procedure contemplated.
But
my
my lord, when your lordship had said that you should state on affidavit that persons who have not applied should not be appointed. Para 4 of your lordships. Further, the affidavit should specify that the candidates who did not apply in response to the advertisement shall not be offered appointment.
That we are referring to Anjali Bharadwaj, so we are just looking for the Anjali Bharadwaj.
Yes, my lord. Annexure P1. Para 67, my lord. Page. It's a very exhaustive judgment on this. Page 43, my lord. These are the general directions, my lord. Insofar as transparency in appointment of information commissioners is concerned, pursuant to the directions given by this court, the central government is now placing all the necessary information, including issuance of advertisement, receipt and applications, particulars of the applicants, composition of the selection committee, etc. on this website. All states shall follow this system, number 1. Then, my lord, third, likewise, it would also be appropriate for the search committee to make the criteria for shortlisting the candidates public, so that it is ensured that the shortlisting is done on the basis of objective and rational criteria.
That, Mr. Bhushan, they will comply with,
They are not.
At the time of selection.
No. This has to be done before. That's why your lordship's order said that you file an affidavit pointing out what is the shortlisting criteria. 7 January order says so for this reason. So no shortlisting criteria has been put out. Names of applicants have not been put out. Names of shortlisted candidates. Then, my lord, the last paragraph, para 5 says, we would also like to impress upon the respondents to fill up the vacancies in future without any delay. For this purpose, it would be apposite that the process for filling up particular vacancy is initiated 1 to 2 months before the date on which the vacancy is likely to occur, so that there is not much time lag between the occurrence of the vacancy and the filling up of the said vacancies. Today, my lord, 5 orders of your lordship. Fill up. Your lordship keeps noting that there are now 7 vacancies, now 8 vacancies, etc.
You are absolutely right that there is a delay, but now we are at a
delay of how much, my lord? It's a delay of.
You are right. That's why they say give 2-3 weeks time. So 2-3 weeks is not something that we can. Now we have reached at least.
But at least, my lord, I know that now your lordship cannot set the clock back except call them up for contempt. That's all that this court can do. But this court should and must at least ensure that there is full transparency in the appointment process. That was the whole object of those directions in the Anjali
That's
Bharadwaj
what we
case.
are saying, that we are absolutely confident that they are fully aware of the judgment of this court.
But they are not complying with it. They have said in their affidavit that we will not comply. They have said.
Search committee has now completed the exercise.
Pardon, Lord?
Search committee has already completed.
But
the
list of
exercise.
shortlisted candidates.
Search committee can't lay down the selection criteria. Selection criteria will have to be evolved by the selection committee.
So that had to be put out prior.
So let us see
Search
that.
committee, my lord, what's the object of your lordship
You
saying?
may be right.
That the search listing criteria has to be formulated and put out in the public domain.
Mr. Bhushan, that's why we are hinting you that you are right. We have already directed. So let's see that how the compliance is made.
But my lord, this process will go on like this. They will go on airdropping without any transparency. If your lordship does not hold them up to what your lordships had
So
directed.
therefore, let us take it after 3 weeks. We will come to know, you will also come to know the how the appointments are made, who are the persons appointed. Assuming that there are some eminent persons are offered upon.
But why should it not be put out?
They will.
But my lord, why after the appointment? Of course, after the appointment, we will come to know. But my lord, when your lordship said that the names of the applicants, the names of the shortlisted candidates, and the shortlisting criteria has to be put out. After all, my lord, we are enforcing the Right to Information Act.
Criteria definitely they will have to. They will.
But they have not. It's been 10 months.
They will not, because the selection committee probably has not met, or them they meet. They will have to revolve.
The selection criteria has to be laid out for the search committee. For the shortlisting criteria for the search committee.
Search committee is not the selecting authority. Search committee can only lay down a criteria in terms of eligibility prescribed in the statute.
I'm not saying that the search committee has to lay down. I am saying that the government has to lay down what is the criteria for shortlisting candidates. 1,000 applications, they need to make a shortlist of, let's say, 40, 30, 40, whatever. How will they shortlist, on what basis? How will this be avoided? That one journalist who has no qualifications whatsoever, he is just airdropped and appointed. How will this be avoided?
We can't comment on anyone because he not participated.
I'm not saying that, my lord. I'm giving that as an example because it has happened.
So therefore,
And they are saying that it will happen again. In their affidavit, they are saying that we will do it.
no, they are not saying that they will do it. They are only trying to say that maybe that there are some persons of eminence sometime, they may not like to apply.
That's right.
And suppose you find, and genuinely.
But my lord, what is the problem in putting out, when your lordship said that applications as well as the shortlisted candidates?
Selection committee will have to meet. For example, today,
Yes.
Five of us, we think that somebody is genuine person.
Yes.
Today we put his name and he declines. What will happen? So let us see that how they are completing the
Shortlisted
exercise.
candidates, your lordship said that names of the shortlisted candidates, there are two lists, applicants and shortlisted. Suppose they are shortlisting somebody who is not among the applicants also, at least that shortlisted candidates list should be put out in the public domain.
That way today, let us see, because right time, let the right time come today. There will be
But the
a
right-
trial.
What is the right time, my lord? What is the object of this
The
direction?
object is that when the selection committee meet,
Yes,
by that time, suppose those who have applied, their consent is there because they have applied.
yes.
Those who are shortlisted and have not applied, the selection committee must find out from them that are they willing to be considered. If they are willing, then selection committee will
But
notify the
once-
criteria.
They are saying that they have shortlisted. This is the statement made
They are
today.
shortlisted by search committee, not by.
Yes, by search committee. Search committee shortlists and then the selection committee selects.
And there are parameters
Now
under the
there are-
statute.
there are-
Parameters under
there
the
are- there
statute.
are-
If there is any violation, they have to point
So
out
there
there
is
is a
a
violation
list-
of the
There
statute.
is a list
Now they
of-
can't make this argument before everything is done.
there is
Nothing
a
has
list of
happened.
shortlisted candidates. That list, they have
There will
said.
be two things, Mr.
Yes.
Bhushan. One is that appointment of an ineligible candidate.
Yes.
One, there your argument and probably the court's view will be different.
Yes.
Second will be a person who is eligible, but where you will say comparatively, there are better persons who had also applied.
Yes,
Why
yes.
they have been overlooked?
Yes,
That will be a different kind of yardstick.
yes.
Even the scope of judicial review will also be different from where
But
you.
this is not merely a question of judicial review, Lord. This is a question of the people's right. How did this right to information come about, my lord? Started with that Rajnarayan Indira Gandhi case.
Right.
Then thereafter SP Gupta, where this court said unequivocally
So for
that
that purpose, for enforcement of that right, there has to be an institutional, functional institution there. That functional institution which has now been envisaged through a parliamentary act. Now that act also gives some qualifications, prescribes the minimum eligibility criteria. Maybe somebody will be well within right to say that, look here, despite the statutory criteria having laid down, an ineligible person has been appointed.
but before that, my lord, before the appointment, what are we asking for? We are asking that there should be at least transparency, and that's what the court agreed in Anjali Bharadwaj and thereafter your lordship's order of 7 January. In both orders, this is there as the right of the people to know, number one, who are the people who have applied. Firstly, what is the shortlisting criteria? Who are the people who have applied? Who are the people who have been shortlisted? At least that the people have the right to know before the appointment.
Oh, this information will come in public domain, no doubt, but.
No, it will not.
appropriate stage.
It will not. Only the appointments will come in the public domain.
No, we will get that information also.
No, your lordship may, because this, the people need to know before the appointments are made. So that, my lord, suppose they are appointing somebody.
They are
who is
mixing up,
totally
they are mixing
unqualified.
up, they are mixing up two issues.
They are-
One is eligibility, other one is suitability. Eligibility is provided under the act. If somebody is appointed, defaults the eligibility, that can be struck down anytime.
Obviously, that
Yes.
you can always do.
Then the suitability not as they dictate. He is suitable, he is unsuitable,
I
he
am
can't
not saying
dictate all
I
those things.
dictate, I am saying that at least let me come to know who are the people
is-
who are being considered for appointment.
Mr. Bhushan, that we will
But not-
ensure that the entire information comes, but look at the way the all public service commissions, other selection bodies do it. At least there is a set practice, a convention which is followed.
But my lord, here your lordship had, after a detailed judgment in Anjali Bharadwaj, after exhaustive arguments about that whole case was about transparency in appointments.
Absolutely.
And therefore, this court, after considering everything, laid down, gave certain directions that this needs to be the transparency in appointments. On the basis of that order, your lordship passed a specific order on 7 January saying that you have to do this, file an affidavit saying
That's
these.
why we are saying that at least with all these efforts which have been made by the court, of course, these initiative goes to the petitioners. We have now reached a stage where the selection is likely to be finalized within 2-3 weeks.
But my lord,
Let
before
us
that,
see
why
what-
should they not, today itself or tomorrow, why should they not put out this information in the public domain? What is the impediment? They are saying that people will be slandered, etc. That way you can say that there will be no transparency for any appointments whatsoever.
Transparency will have to be there, number one. At an appropriate stage, all the names will have to be, even those who are shortlisted and those who are not shortlisted.
But what is the appropriate stage? The appropriate stage,
Appropriate stage
as
will be-
stated by this court was
Appropriate stage will be.
prior.
Appropriate stage will be that the selection committee,
Yeah.
before it actually goes for a selection, must evolve the criteria. Criteria must be not seen toward the candidate.
No, criteria
must be
was for
free.
shortlisting. That was the shortlisting criteria.
No, we are talking of the selection criteria.
No. Your lordship's order says that the shortlisting criteria, because they are saying some secretaries have shortlisted. Now, what is the criteria on the basis of which these secretaries shortlisted the candidates out of 1,000? Which 40? How did they select these 40? Shortlist the 40? That's the criteria which had to be put out.
Mr. Bhushan, let us also remember, if we start having the judicial scrutiny of every stage, the selection will never finalize.
Not a question of scrutiny. I am not saying that. I am saying simply transparency, simply public
scrutiny-
domain.
Transparency, we will ensure that the names are, but today, if they disclose, then tomorrow there will be a petition, this is wrong, why this person has been there, he is so and so, therefore disqualify him.
But my lord, that in any case
Instead
cannot
of
be
that,
prevented.
Instead of that,
Suppose your
therefore,
lordship starts saying
let us see,
this, that
let us
because
see.
there will be a fear
no,
of
no,
a
no, no,
petition.
Mr. Bhushan, the things are very easy. Suppose there are 100 applicants
Yes,
and appointments are to be made only 9 or 10.
yes,
So let us concentrate on the 9 or 10 who are ultimately appointed, and along with, of course, with reference to the criteria, with reference to those who are not selected.
but my lord,
Comparative will have to be between them only.
so when the court in Raj Narayan and SP Gupta said that in a democracy, the people have a right to know what the state or their agencies are doing in all their aspects. Therefore, on that basis, this court, when seeing what is the transparency that needs to be done,
That right to know is definitely there, and it has to be there. There can't be any exception to that.
so the right to know even the short list, the right to know even the shortlisting criteria, all that are part of the right to know of the citizens
Shortlisting
of this country.
Shortlisting is, for example, in a public service commission or in any selection committee, advertisement is issued.
Yes,
Candidates apply.
yes,
What is the purpose of shortlisting them is only to ensure that no ineligible person is considered,
yes,
right?
yes,
Now, therefore, if any ineligible person is considered and consequently appointed,
yes.
we will examine it. It's not
But
question of.
Lord, this prior stage, there are three stages. One is applications, then shortlisted candidates, and then the selections. In this intermediate stage of shortlisted candidates, why should the people of this country, why do they not have the right to know? And that's what this court said in Anjali Bharadwaj, and your lordship 7 January order just reiterates that.
Yes, we will
And
ensure that right.
the states are disclosing the names. Why should the central government not disclose?
They will make sure that they will disclose it.
But they should disclose it now, before the selections are made, before the appointments are done.
So we have heard learned counsel for the petitioner.
And again, my lord, in the states also similar thing is happening. We handed over that.
Additional Solicitor General of India.
Jharkhand is defunct, Himachal is defunct.
We are just coming to that part. We are informed as regard to the Central Information Commission. We are informed that the search committee has completed its exercise, and the selection committee comprising 1I, the Prime Minister of India, 2I, the leader of opposition, and 3I, a nominee of the third member will be nominee of the government of India, or
That's a union cabinet minister to be nominated by the prime minister.
and the third member to be nominated
In this kind of
terms
selection, my lord, the government.
No,
does-
you don't trust anybody. You
Runs
will
the
not
thing.
trust anybody. What is there in under the act, that is what.
Leader of opposition
He
will
will not
keep
trust
saying
anybody.
whatever he
He
wants.
does not trust anybody except
They
himself.
will just appoint whoever they want. And they will airdrop people.
No, but that is what the statute says.
Yes, statute says. Section 12
That
is
is
there.
why transparency is required.
Will,
That is why transparency is required.
Section 12(3),
so-
kindly have a look at.
will consider the applicants within a period of 3 weeks.
Because the statute says that in the election commissioners also, which we have challenged before your lordship, that case is pending before your lordship.
This provision,
Same thing, they removed the chief justice after a constitution bench for the election commissioner said that prime minister,
was the election
leader of opposition and chief justice. They removed chief justice and said another minister.
this act is also under challenge.
No, this is not under challenge.
challenge.
That is under challenge.
That election.
I'm saying that is under challenge. Same provision is under challenge. This one is not yet under challenge, but I'm saying that they effectively just do that. They ignore all
His
dissent
argument, what
notes
is
are ignored.
contrary to the act, without challenge, he can't make these arguments.
We have no reason to doubt that the Union of India shall follow the principles to guidelines laid down by this court in Anjali Bharadwaj's case, and shall finalize the selection process at the earliest. Post the matter, keep it on a miscellaneous day, keep it on a miscellaneous day, except after 3 weeks.
Your Lordship may list it after 2 weeks or, because they have said that everything has gone to the,
They are saying 2-3 weeks, so we keep it
Correct.
on a miscellaneous day, on a Monday, because otherwise the turn does not come on a
so
Monday, exact after 3 weeks.
they should fill all the vacancies.
No,
They
you
are-
don't dictate how much we are going to do.
You
it.
don't dictate.
You don't dictate
There are
anything.
10 orders of this court
will-
that say
we
that you
know how
have
to
to fill
defend
up
it.
all the vacancies.
Let us see how much we are, that's why we are also watching, we'll like.
He is saying you don't dictate. Court has been dictating for so many.
No, we obey the
So
order,
many
but you
orders.
don't dictate you how many we have to fill up. and
You
how
are
many
not
to fill up.
obeying the orders. You are not obeying the
You
order.
initiate
17th
appropriate
November.
action. We'll defend.
We'll take up on a Monday.
Please.
What date is your Lordship giving?
17th November, exact 3 weeks.
All right.
Great.
The other states also, my lord.
Oh, sorry, give us, next paragraph. We
Lordship may say that all the other states must fill up
further
the.
find from the information on report that states of Himachal Pradesh.
If your Lordship just sees that table, your Lordship will come to know what is the situation in the other states. Jharkhand is defunct. Himachal is defunct. Chhattisgarh has only one.
It's
No, Himachal and Uttarakhand are defunct.
Jharkhand and Himachal are defunct. Chhattisgarh has only one information commissioner,
it's
even
two.
though
In
there
fact,
I am
are.
appearing for Uttarakhand. Uttarakhand is perfectly functioning. All five appointments are there. There are one CIC.
File the compliance affidavit.
Compliance affidavit is also there. 16 June 25.
I appear on behalf of
16 June
Chhattisgarh.
25. My affidavit is there, my lord.
No, Mr. Bhushan, he is right. They have 3+1 you appointed.
Now 4 plus 1. All are there. Can you keep my statement, my lord? All are
Himachal
functioning.
also, Mr. Bhushan, they have
We
appointed.
are not on Uttarakhand, my lord. I am just go through the chart one by one. Just see, my lord, first Jharkhand, defunct since May 2020, 5.5 years. Zero. And they are not even entertaining appeals now. Himachal Pradesh, zero. Defunct since
No, Himachal Pradesh, correct us, there is CIC plus 1 IC.
zero. The first column is how many existing. In that list, that just see my chart. This is a chart as of today. Himachal Pradesh, zero. Chhattisgarh, only one.
It's two. Chhattisgarh, there's another problem that has occurred, The selection process was challenged before the High Court, and that is still pending. We're trying our best to resolve it.
Subject to outcome of that, you can proceed. If
No,
there is
there's
no-
a stay. There's an interim order. The selection
Then
process
that's what
itself
I
is stayed.
Point out that these proceedings.
We have filed a detailed reply before the High Court pointing out the affidavits of this court. In fact, we'd also stated that we were supposed to complete the process
Do
by.
you have the number of that proceeding?
Yes, Manoj.
Jharkhand, my lord, they have not even
WPS.
filed a status report.
Manoj,
Though they had said that they will, because Jharkhand, they were saying that there is no leader of opposition. Then your lordship said that all right, treat the leader of the largest
Well, the
opposition
lead
party.
matter- Manoj,
Yet, my lord, nothing has happened.
the lead matter is WPS, Writ Petition Service, number 3775 of 2025. Manoj.
This you are talking of Jharkhand or
Chhattisgarh,
Chhattisgarh? Take counsel for the state of Chhattisgarh point
In
out
fact,
that,
yesterday also we have filed another affidavit, Manoj.
that as a result of an interim order passed by the High Court in schedule number so and so, comma, the selection process for appointment of CIC stock information commissioners has come to a standstill. Instead, since the postings regarding appointments are being monitored by this court, comma, we request the High Court to take up the matter, to take up and decide the matter finally within a period of 4 weeks. Within a period of 4 weeks, the Registrar General of the High Court shall send a compliance report.
Then see Maharashtra. Maharashtra, my lord, there are
We further find
90,000 pending appeals. There are 3 vacancies, and yet they have not been appointed for a long time. Karnataka, 50,000 pending appeals, 3 vacancies.
We further find from the report that despite large scale vacancies unfilled, comma, the states of Maharashtra, Karnataka,
Even Tamil Nadu, my lord, just see the pendency, 41,000.
Madhya Pradesh, But there is only one vacancy there.
Yes, but then they have to sanction more because the strength is on the basis of how many appeals come, therefore how many people are required.
Just a minute, Madhya Pradesh.
Madhya Pradesh, my lord, 7 vacancies. West Bengal, 3 vacancies.
Are directed to
Andhra
initiate-
Pradesh, 4 vacancies.
are directed to initiate the selection process within a period of 4 weeks and submit compliance reports. Within a period of 3 weeks and submit compliance report. Next paragraph. Similarly, the states like Tamil Nadu, Odisha, Karnataka and Maharashtra may require to sanction more posts, keeping in view the large scale pendency of appeals stroke complaints under the Information Act in these states.
Bihar also, my lord.
Bihar,
Bihar
Bihar with 30,000, yes. Full stop.
Tamil Nadu also.
Tamil
Because
Nadu we have included. Let the state governments take an appropriate decision in this regard. And apply this code. Full stop. Next paragraph. All the state governments are further directed to file their respective status report with respect to the latest sanction strength, the post filled up, and the selection process, and the stage of the selection process, if any, already initiated. Then say post on 17th November, Monday.
in fact, Jharkhand, your lordship should summon the chief secretary because
They have not
despite
done anything.
Jharkhand,
Jharkhand, they have not done anything.
no,
Jharkhand,
zero.
Manoj, I appear for the state of Jharkhand.
5.5 years.
We have filed an affidavit, Manoj, seeking Manoj, some time, Manoj, of 45 days to complete the process.
Order was
No,
passed in January.
So much time has already been granted, Mr.
We have
Chaudhary.
given reasons in the affidavit, Manoj. What we are saying is, Manoj, leader of opposition was not in place. Now everything is in place, Manoj. We are seeking 45 days because the advertisement which was issued was in 28th June 2024. Now, Manoj, some of the candidates, Manoj, they have crossed that threshold days of 65. So we
Could
are,
issue a supplementary
yeah, we are
advertisement.
issuing that supplementary affidavit, advertisement, and then, Manoj, we'll conclude the process within 45 days. But that's the
Why
status.
why have they not done it since January? Your lordship's order is of
We have filed
January.
an affidavit, Manoj.
Chief Secretary State of Jharkhand is directed to ensure that the selection process is commenced within.
Look, it's already in place. We'll issue a fresh advertisement and then complete it within 45 days, Manoj. That's the affidavit we have.
Is directed to ensure that the pending selection process is completed in all respect within
45 days.
45 days, and a compliance affidavit will be filed, failing which this court shall be constrained to take appropriate action.
What they do is, despite 10 months having elapsed since your lordship's order, they wait till the hearing. They don't do anything till the hearing. Then they
Then they
say,
come out with it.
now we will try and do it in the next 45 days. This is the whole
That is
strategy
Jharkhand
that
typically
we
has
are
done
saying,
like
seeing
no
everywhere.
reason. You don't invite any harsh order, please tell them.
We'll do that.
immediately do.
45 days.
That's all right. They are killing the Right to Information Act. They are destroying the Right to Information Act in this manner. All these governments seem to have taken a decision. This is how we will destroy, because no government wants transparency. No government wants that people should come to know what they are doing. And therefore they say that, well, best way to destroy the Right to Information Act is not to appoint Information Commission. This is what they have been doing. Central government is also doing that.
Now we'll take up it now every 2 weeks on Monday. That's
Very
the
well.
only way to ensure.